You have issues, but you're ready. Lombardi, you have not commented about the second accused.
One comment is that we will try for someone for the second accused what we deal with that.
Proceed.
Natembeya, which language do you understand? English or Swahili? Which language do you prefer?
Mine is not active.
Count number 1 against accused number 1. Conflict of interest contrary to section 42(3) as read with section 48 of the Anti-Corruption and Economic Crime Act of 2003. Particulars of the offense being George Natembeya between 1st January 2023 and 30th April 2025 within the Republic of Kenya, being an agent of a public body to which the governor of the county government of Trans Nzoia knowingly acquired and indirectly pecuniary interest in the sums of Kenya shillings 1,127,900 from Mercy Chelagat, the director of Lima Agro Science Limited and the proprietor of Myra Stores, which traded with the county government of Trans Nzoia. Is it true or not true?
Not true.
Count number 2, conflict of interest contrary to section 42(3) as read with section 48 of the Anti-Corruption and Economic Crime Act of 2003. Particulars of the offense: George Natembeya between 1st January 2023 and 30th April 2025 within the Republic of Kenya, being an agent of a public body to which the governor of county government of Trans Nzoia, you knowingly acquired an indirectly pecuniary interest of the sum of Kenya shillings 2,124,668 from Emmanuel Wafula Masungo, the beneficial owner of Easterly Wheels Limited, which traded with the county government of Trans Nzoia. Is it true or not true?
Not true.
Count number 4, unlawful acquisition of public property contrary to section 45(1)(a) as read in section 48 of the Anti-Corruption and Economic Crimes Act of 2003. Particulars being you, George Natembeya, between 1st January 2025 and 30th April 2025 within the Republic of Kenya, being the governor of Trans Nzoia County Government, you unlawfully acquired public property to which Kenya shillings 3,252,568, being part of the payment made by public government of Trans Nzoia to Lima Agro Science Limited, Myra Stores and Easterly Wheels Limited in conflict of your public interest. Is it true or not true?
Not true.
Jerry?
Your Honor, these are the simple charges in the case of. We are actually shocked to see that we've been served in an affidavit by the petition to purport to oppose bail. The directions you need to give us is whether you wish the prosecution to go fast, you will respond to it, because you would have expected the narrative that the accused person should have been released on bail, actually free bail, so to speak. But we have an affidavit that is served on us now to be charged. Even if I may, my name is Awiti. We have instructions to oppose bail, instructions from our client, the Director of Prosecutions. And as regards Mr. Njeri's request for directions, we believe that because we oppose bail, and bail being ordinarily a right, then it has to go first in an application to oppose bail. They'll have a chance to respond to our application. As a prayer, when I can go upon our arguments, my learned senior Mr. Akula will take the court through the affidavit, the functional matrix. Allow me to take the court through the legal matrix. Now, I'll start by indicating that the law on bail is almost settled. Sorry, Your Honor.
So is
recording. My apologies. My apologies. I come from the lakeside. I speak
Very well. I know.
Your Honor, our application in Thank you, Your Honor. Like I was indicating, the law on bail and bond in Kenya is settled, or almost settled, if not settled. And our arguments are founded on Article 59(1)(h) of the Constitution. Article 50, there, sections
159,
sorry, Article 49(1)(h)
49(1)(h)
of the Constitution. 50, there, section 123 and 123 capital A of the Criminal Code. And of course, section 8 of the Magistrates Court Act, which gives this court the jurisdiction to entertain these matters. You know, it is the import of Article 49(1)(h) that bail is a constitutional right, and that every arrested person or an accused person has entitlement to bail unless there are compelling reasons to deny bail. We submit to you, and we believe that at the tail end of our submissions on the prosecution side, we shall have established at least 3 compelling reasons, at least 3, there could be more, to justify this court's denial of bail for the accused person before you. And Your Honor, just to emphasize, the import of Article 59H is that while bail is a constitutional right which should ordinarily be granted, where such compelling reasons are established, the court must deny bail. You know, that you do not have a discretion. Where we establish compelling reasons, you cannot exercise any discretion. You must deny bail. And Your Honor, just on the question, so
Yes,
Your Honor, unfortunately, I'm not able to read the court's pen. I'm short as well. The court could guide me when I'm able to proceed. I appreciate that.
every sentence was.
Thank you.
Carry on.
Yes. Your Honor, that further on the question of discretion, the discretion that the court has on the question of bail then arises where the court has dismissed all the compelling reasons and is to set terms and conditions of bail. Therefore, Your Honor, where there are compelling reasons, as is our submission, then the court cannot grant bail, and therefore the court does not have to get to the discretion of setting terms or conditions of bail. You know, because I have had the benefit of appearing in the number of counsel for the defense in this matter, I can preempt what they are likely to tell you. That the right to bail is also, I am normally wrong, so I may be wrong to preempt them, but I promise they will say what I'm telling you.
If you can give them a chance to state what they are.
I am allowed to preempt and give
The
argument.
defense has the capacity, Your Honor, and we will not want the counsel to belabor, to just speak for the state which it
A minute.
represents. The accused has sufficient
A
defense.
minute. Decorum. Decorum. I repeat for the third time. Decorum. Mr. Witty, can you give directions? Give the defense time to state what they have to state. State what you have to state.
That's right.
Very well.
You know, there is the question of the relationship between the right to bail and the presumption of innocence. You know, it is straight law.
Pause.
Oh.
It is right law.
It is straight law that the denial of bail, where there are compelling reasons, is not a breach of the presumption of innocence. You know, I trust the court to have a look at the Tomley case. I'm not very good with spelling and pronunciation of the word. We do not have copies of that authority, but because this court can notice there, the Tomley case is is clear on the relationship between the right to bail
High
and...
Court or Court of Appeal?
Sorry?
At the High Court level or Court of Appeal?
The High Court, sorry, the High Court.
High Court level.
Yes. And therefore that if this court finds that there are compelling reasons, or at least one, Your Honor, because just one compelling reason is sufficient to deny bail, then that does not in any way breach the presumption of innocence. Your Honor, I will also invite you to Article 24 of the Constitution, vis-a-vis Article 25 thereof, on the limitation of rights under the Constitution. And the effect thereof is that the only rights that cannot be limited are the rights under Article 25. And that the right to liberty or any other right that may be alleged to be violated, including the right of presumption of innocence, by denial of bail, can be permissibly limited by dint of Article 24 of the Constitution. You know, the net effect thereof is that a denial of bail where there is compelling reason or compelling reasons amounts to a permissible limitation of rights under Article 24 of the Constitution. Whereas a compelling reason has not been defined by statute in Kenya. We have guidance from the Judiciary Bail and Bond Policy Guidelines.
Number E024 of 2025, Republic versus George Natembeya.
President John.
A minute.
Walubengo, Wanigilo. President John.
So the last name?
Walubengo, Wanigilo. You're just been served the charge sheet now. So you just get move on.
Lombachi, you have not commented about the second.
Kenya shillings 1,127,900 from Mercy Chelagat, the director of Lima Agro Science Limited and the proprietor of Myra Stores, the beneficial owner of Easterly Wheels Limited, which traded with the county government of Trans Nzoia. Is it true or not true?
It's not true.
The payment made by public government of Trans Nzoia to Lima Agro Science Limited, Myra Stores and Easterly Wheels Limited in conflict of your public.
Mr. Jeru.
No, Your Honor, I the petition to propose to vote the direction sections you need.
We believe that because we oppose bail, and bail being ordinarily a right, then it is has to go first in an application to oppose bail. Then we take the court through their affidavit, the functional matrix. Then we take the court through their affidavit, the functional matrix. Allow me to take the court through the legal matrix. And I'll start by indicating that the law on bail is almost application in Article 50, there, sections, and that every arrested person or an accused person entitlement to bail. I am normally wrong, so I may be wrong to preempt them, but I promise they will say what I'm telling you.
If you can give,
I promise they will say what I'm telling you.
if you can give them a chance,
The council,
if you can give them a chance,
the council to deliver,
give them a chance.
the council to deliver, just speak for the state which it represents.
A minute.
To deliver, just speak for the state which it
A minute,
represents.
a minute, a minute.
Speak for the state which it
A minute,
represents.
a minute, a minute.
The accused has a sufficient
A
defense.
minute. Decorum.
Accused has a sufficient
A
defense.
minute. Decorum. I repeat. Decorum. I repeat. For the third time. For the third time. Decorum. It is by law.
It is strike law that the denial of bail where there are compelling reasons is not a breach of the presumption of innocence. Then I trust the court to have a look at Chomli case. I'm not very good with the spelling of the pronunciation of the word. We do not have copies of that authority, but because this court can notice the Tom Chomli case is clear on the relationship between the right to bail
High
and...
Court or Court of Appeal?
Sorry?
And the High Court level or Court of Appeal?
The High Court, sorry, the High Court.
High Court level.
Yes. And therefore that if this court finds that there are compelling reasons, or at least one, Your Honor, because just one compelling reason is sufficient to deny bail, then that does not in any way breach the presumption of innocence. Your Honor, I will also invite you to Article 24 of the Constitution, vis-a-vis Article 25 thereof, on the limitation of rights under the Constitution. And the effect thereof is that the only rights that cannot be limited are the rights under Article 25. And that the right to liberty or any other right that may be alleged to be violated, including the right to presumption of innocence, by denial of bail, can be permissibly limited by dint of Article 24 of the Constitution. The net effect thereof is that a denial of bail where there is compelling reason or compelling reasons amounts to a permissible limitation of a right under Article 24 of the Constitution. Whereas a compelling reason has not been defined by statute in Kenya, we have guidance from the Judiciary Bail and Bond Policy Guidelines, Judiciary Bail and Bond Policy Guidelines, together with several decisions of superior courts in the land, that is the Court of Appeal and the High Court. And Your Honor, that the list provided in the Judiciary Bail and Bond Policy Guidelines is not exhaustive. But without going to the particular facts which my learned senior Mr. Kula is following me to talk about, that list includes as compelling reasons the likelihood of interference with witnesses, the likelihood to interfere with ongoing investigations, and the likelihood to interfere with exhibits. In concluding on the legal issues, the primary purpose of